Welcome, everyone. I am so glad you're here for this final review explainer. You've spent the entire semester really digging into the weeds of the criminal justice system, studying all the specific definitions, the intricate court cases, the rules. But today we're going to do something a little bit different. We're going to zoom all the way out. Think of this explainer as your ultimate big-picture conceptual review. We're going to take the second half of the course and stitch it all together into one continuous, honestly fascinating story. We are looking at the entire post-conviction journey. Because to truly master this material for your exam, you can't just memorize facts. You need to understand how a judge's underlying sentencing philosophy directly shapes the physical reality of our prisons, how that reality drives the absolute necessity for community corrections, and how those exact same challenges are completely reimagined when the offender happens to be a child.
So, let's dive right into it. Everything we're reviewing today is really driven by one monumental question. After the gavel actually falls, what happens next? Every single thing we study, from the type of food served in a supermax prison facility to the specific conditions of juvenile probation, right down to the staggering caseloads of parole officers, it all stems from an initial foundational choice. And that choice is about exactly why we punish people in the first place. Think about it. You literally cannot build a system without a blueprint. And in the criminal justice system, our philosophical goals serve as that blueprint.
Let's kick things off with Section 1, the architecture of punishment, and those competing philosophies.
It's fascinating how our 5 major punishment philosophies split right down the middle based purely on time. On one side, we have retribution. This is entirely backward-looking. It's that age-old concept of just desserts, or an eye for an eye. Think of it like paying a really steep fine for speeding. The system doesn't necessarily care about changing your future behavior. It only cares that the punishment is mathematically proportional to your past offense. But on the flip side, we have our forward-looking philosophies: deterrence, rehabilitation, and incapacitation. These are all about manipulating future behavior. Deterrence uses the fear of swift, certain consequences. Rehabilitation uses education and targeted treatment to cure the root cause of the behavior. And incapacitation? Well, that relies on physical removal, just taking the person out of society entirely so they literally cannot reoffend.
But there is one philosophy that stands completely apart from the rest of the pack, and that is restoration. This one is unique because it totally flips the script. It shifts the spotlight away from the state and places it directly onto the victim. Restoration seeks to actually repair the harm by bringing the victim, the offender, and the community together to find a joint resolution. And honestly, it's pretty predictable. Because it centers on the people who are actually harmed, it consistently results in the highest satisfaction rates among all of our punishment models.
Moving right along to Section 2, the sentencing ripple effect, and setting the course.
So how does a judge actually turn those abstract philosophical ideas into a real-world reality? Well, through their sentence. If a society deeply values rehabilitation, we use indeterminate sentencing. This gives judges the flexibility to set a range, say 5 to 15 years, and it gives a parole board the discretion to release an individual when they can prove they are truly rehabilitated. It actively incentivizes good behavior. But when the public gets frustrated and demands guaranteed punishment and consistency, the system swings hard over to determinate or mandatory sentencing. With this, you get a fixed term. 10 years just means 10 years. And while mandatory sentencing eliminates judicial bias and definitely increases predictability, it also completely strips away individual context, and crucially, it has been a massive driver of the prison overcrowding crisis we see today. And this dynamic brilliantly illustrates how courts are forced to weigh these competing ideas, especially when the stakes are absolute life and death. Think about the mechanics of the death penalty. Following the landmark Supreme Court case, Gregg versus Georgia, the court didn't just rubber stamp executions, they required a deeply structured, very careful balancing act. During the sentencing phase, juries are now required to systematically weigh aggravating factors, things that increase the severity of the crime, like premeditation or torture, against mitigating factors, which reduce moral blameworthiness, things like severe mental illness or a history of abuse. It is the ultimate attempt to balance severe retributive punishment with individualized justice.
All right, Section 3, confinement versus community, and the practical application of all this.
To see how wildly our philosophies have shifted over time, it's like watching a giant correctional pendulum swing back and forth across history. We started way back with the Pennsylvania system, using strict isolation and solitary confinement for religious penance. But when that proved completely mentally devastating to inmates, we shifted to the Auburn system of congregate silent labor. Then, realizing that just locking people up wasn't actually changing their behavior, we entered the reformatory era. We introduced treatment, good time credits, a pure rehabilitative approach. But you know the pendulum always swings back, right? By the late 20th century, we entered the punishment era, a massive get-tough period of mass incarceration, driven purely by incapacitation and retribution.
Now, inside our modern facilities today, we manage this incredible volume of people through the process of classification. But keep in mind, classification isn't just about security levels. It's deeply philosophical. We look at static risk factors. Those are the things that literally cannot be changed, like the age of someone's very first arrest. But much more importantly, we look at dynamic risk factors. These are the changeable issues: untreated drug addiction, lack of education, or unstable employment. Focusing our institutional resources on fixing these dynamic factors is the absolute heartbeat of the rehabilitative philosophy. The idea is simple. If we can change those factors, we can change the future.
But here is a massive reality check for us. We cannot physically incarcerate everyone. When you look at the sheer numbers, the volume of people under correctional control is staggering. But notice that the vast majority, nearly 3 million people, are actually out on probation. Community corrections are not just some lighter, easier sentence. They are quite literally the vital pressure valve keeping the entire mass incarceration system from completely collapsing under its own weight.
Now, to keep people out of those overcrowded prisons, we heavily utilize diversion programs and specialized courts, things like drug courts or mental health courts. And don't get me wrong, these are massive wins for rehabilitation because they focus on coordinated care rather than just chasing a guilty verdict. However, you absolutely must remember their unintended systemic consequence: net widening. This happens when the creation of all these alternative programs inadvertently pulls more and more people into the justice system for minor behaviors that previously would have just been ignored. We build a wider net, and inevitably, we catch more people.
So how do we actually supervise all these individuals out in the community? Okay, this is a heavily tested distinction, so definitely lock this in for the exam. Probation is a front-end alternative. It's handed down directly by a judge to keep someone out of prison entirely. Parole, on the exact opposite hand, is a back-end, early release from prison, and that is decided by a parole board. While the mechanics of how you get there differ, both of these tools are frantically trying to balance offender accountability with the ultimate goal of successful societal reentry. And let me tell you, that reentry process, it is brutally difficult. Formerly incarcerated individuals face a mountain of barriers. They carry the permanent, stigmatizing label of a criminal record, which immediately limits their employment and their housing options. They very often face severe healthcare gaps, untreated addiction, all while trying to navigate a world that has completely stripped away their social support networks. So here is the big conceptual takeaway for this chapter. When reentry fails, recidivism happens. And when recidivism happens, it proves that mere incapacitation has fundamentally failed to produce long-term public safety.
That brings us to Section 4, the Juvenile Justice Parallel, a system built on a completely different foundation.
To really grasp juvenile justice, you have to understand one foundational Latin phrase, parens patriae, meaning the state acts as a parent. Under this philosophy, early reformers decided that the state had a moral and legal duty to step in and act in the best interest of a child if their own parents were failing them. This one idea birthed a completely separate justice system, a system that actively refuses to treat children as miniature adults, recognizing that adolescent brains are still developing and that rehabilitation must always be the primary directive. Think about how this philosophy is so deeply ingrained that it literally changes the vocabulary we use. The juvenile system actively alters its language to avoid placing permanent, stigmatizing, retributive labels on youth. So while an adult has a trial and is found guilty, a juvenile has an adjudication hearing and is found involved in delinquency. An adult receives a sentence, a juvenile receives a disposition plan. An adult is released on parole, a juvenile is placed on aftercare. It's not just legal semantics, right? It is a direct reflection of that parens patriae philosophy in action.
But as we see so often, philosophy often collides with fear. When a juvenile commits a deeply violent offense, the public's urgent demand for safety sometimes totally overrides the desire to rehabilitate. This is the ultimate tension in the juvenile system, and it is resolved through juvenile waivers. These waivers transfer a youth directly into the adult punitive machinery, and it can happen automatically through legislative waivers at the discretion of a prosecutor or through a judicial waiver after a judge holds a formal hearing. Ultimately, a waiver represents the exact moment our system abandons the child label entirely.
Section 5. The ultimate constitutional balance and the expansion of due process.
Throughout everything we've discussed, our courts act as the ultimate referees, constantly balancing institutional power against individual rights.
Take the adult system, for example. The landmark case Estelle versus Gamble is absolutely critical here. By ruling that deliberate indifference to serious medical needs actually violates the Constitution, the Supreme Court definitively proved a core concept. Adults do not forfeit all their humanity or their constitutional protections the moment they walk through the prison gates. Yes, the state has immense power to punish, but it absolutely does not have the power to abuse.
Now, over in the juvenile system, the shift is even more dramatic. Because those early juvenile courts acted as a parent, they originally gave kids virtually zero constitutional rights. But if we trace the history, we see the Supreme Court systematically dismantling that unchecked power, starting with the Kent and Gault decisions, granting the right to counsel and hearings, then moving to Winship, which required proof beyond a reasonable doubt, protecting them from double jeopardy in the Breed case, and finally, using Roper and Graham to declare the death penalty and life without parole for non-homicides unconstitutional for youth. It is just a stunning, steady march toward granting vulnerable youth real, tangible, constitutional armor.
Finally, Section 6, Final Exam Review, tying together the golden threads.
If you look closely at everything we've talked about today, the entire post-conviction system is really just one eternal balancing act. Whether it's a probation officer writing up a pre-sentence investigation report, a warden classifying an inmate for a supermax facility, or a judge handing down a juvenile disposition, they are all navigating these exact same tensions. They are constantly weighing individual rights against the desperate need for community protection. They are struggling with how much discretion to allow versus the public demand for rigid consistency. And at the absolute core, they are fighting the unending battle between the desire to punish and the hope to rehabilitate. These tensions, they are the invisible hands shaping every single policy we've studied this semester.
Which leaves us with one final, profound thought as you get ready for your exam. The criminal justice system is not just a static set of rules printed in a textbook. It is a living, breathing reflection of our society's values at any given moment. So as our scientific understanding of trauma, of addiction, and of adolescent brain development continues to evolve, how will the next generation redraw the line between punishment and rehabilitation? Keep that question in the back of your mind as you study. Good luck on your final exam, and thank you so much for joining me for this explainer.